Hello and welcome to another episode of Courts Today by LiveLaw. Let us get to today's top headlines. A plea has been filed in the National Green Tribunal to comply with the directions pertaining to maintaining purity of river water during the Mahakumbh 2025. The Supreme Court is inviting applications for position of Law Clerk-cum-Research Associates. Justice K. Vinod Chandran today took oath as a Supreme Court judge. The Calcutta High Court has ordered compensation over pregnant lady's death due to contaminated saline, and the state has handed the probe in this matter to CID. The Supreme Court is set to decide whether limitation period for husband's plea to annul child marriage starts from the age of 18 or 21. The Apex Court has listed Godhra Carnage appeals for final hearing on 13th February. And the Apex Court has granted bail to JJM scam accused Padam Chand Jain in PMLA case and has clarified that bail to Manish Sisodia was not granted under Article 142. This is your host, Urvashi Chauhan, with your daily roundup of legal updates from across the country. Let us start. A plea has been filed in the National Green Tribunal's principal bench seeking directions to Central Board of Pollution Control, Uttar Pradesh Board of Pollution Control and other authorities to ensure the compliance of the guidelines issued by NGT pertaining to maintaining purity of the rivers during the ongoing Mahakumbh Mela at Prayagraj. In December 2024, the tribunal had issued a slew of directions in the case of Kamlesh Singh versus State of UP. It said during the Mahakumbh, the Central and UP Pollution Control Boards would increase monitoring points and frequency on the Ganga and Yamuna rivers to ensure untreated sewage does not affect the pilgrims. Water samples were directed to be taken at least twice a week and analysis reports were to be posted on their websites. Additionally, periodic samples from STP outlets and advanced oxidation ponds were to be collected and uploaded along with online monitoring data. This plea has been filed by ex-Indian Police Service officer and political activist Amitabh Thakur, who highlights that website of the boards does not seem to be carrying any of the facts, data or reports directed by the tribunal, despite the fact that more than 3 weeks from passing of the order have passed and the Kumbh Mela has actually begun. The application states that the matter is of huge relevance and ramifications for the safety of millions of Kumbh Yatris. Hence, it prays for direction to be issued to the pollution control boards, both Centre and UP, to display the sample analysis reports. In the next update, let me tell you the Supreme Court is inviting applications for the position of Law Clerk-cum-Research Associate for the 2025-2026 term. The role offers a monthly salary of 80,000 rupees with a recruitment panel of approximately 90 candidates being formed. The applicants must be between 20 and 32 years old by February 7th, 2025 and hold a bachelor's degree in law from a Bar Council of India recognized institution or be in their final year of study in a 3 or 5 year law course. The selection process includes a multiple choice question round to assess legal knowledge, a subjective written exam to test writing and analytical skills, and an interview. Interested candidates can apply online through the Supreme Court's official website www.sci.gov.in. Registrations have begun on 14th January 2025 and the last day to apply is 7th February. There is an application fee of Rs 500 payable online. For full details and to apply, you can visit the Supreme Court's website and do check the official notification. Justice K. Vinod Chandran was sworn as a judge of the Supreme Court today. Chief Justice of India Sanjeev Khanna administered the oath to him. Earlier this week, the central government had notified the appointment of Justice Chandran, who was the Chief Justice of Patna High Court, as a Supreme Court judge following a recommendation made by the Supreme Court Collegium last week. For those of you who do not know, Justice Chandran was appointed as a judge of the Kerala High Court in November 2011. He was elevated as the Chief Justice of Patna High Court in March 2023. While recommending his name, the Collegium took into consideration the fact that there is no representation on the bench of Supreme Court from the Kerala High Court after the retirement of Justice C.T. Ravikumar this month. The Collegium led by CJI Sanjeev Khanna also noted that during his long tenure as a judge, Justice Vinod Chandran has acquired significant experience in diverse fields of law. At the Supreme Court, Justice Chandran will have a term till 25th April 2028. Moving ahead, the Calcutta High Court has directed the state of West Bengal to provide compensation to the family of a pregnant lady who had died died due to being given allegedly contaminated saline in a government hospital. 4 other pregnant women were reportedly in intensive care after being administered the same solution. The division bench, comprising Chief Justice T.S. Sivangnanam and Justice Hiranyamai Bhattacharya, was hearing a PIL seeking a probe into the death of the pregnant lady due to the contaminated saline. The petitioner's counsel explained that on 22nd March 2024, the Karnataka government flagged a company for supplying contaminated saline and banned it for 3 years, notifying the West Bengal government. Despite this, the contaminated saline continued to be used until a pregnant mother received it, leading to fatal consequences. The issue had been raised as early as 2015, but no action was taken and whistleblowers were silenced. Although the state government had stated in January 2025 that the saline would no longer be used, it was alleged that it continues to be distributed. The Advocate General informed the court that all bottles of the solution are being tested at an independent facility. 3 batches may be contaminated and efforts are underway to identify the specific bottles. He further said that the saline is widely used across India and a tragic incident occurred in West Bengal. Also, the CID is investigating the matter under the Lalita Kumari guidelines on medical negligence. The bench today took exception to the fact that even after an order had been issued in 2024 by the Health Department in Siliguri blacklisting the said drugs, the same was not withdrawn and continued to be used. Accordingly, the court has directed the state to provide compensation to the family of the victim here and has called for a comprehensive report from the Health Department regarding the timeline of events and names of those who were administered the solution. In the next update, the Supreme Court today issued a notice on a petition questioning whether the age of majority for males when calculating the limitation period for filing a petition to annul a marriage under Prohibition of Child Marriage Act should be 18 years or 21 years. In this case, the husband and wife were married when they were 12 and 19 years old respectively. In the year 2013, the husband filed for annulment of the marriage under Section 12, subsection 2 of the Hindu Marriage Act, which provides grounds for the annulment. He later amended his suit to invoke Section 3 of Prohibition of Child Marriage Act, which allows annulment of child marriage within 2 years of attaining majority. The family court had dismissed the annulment suit, stating that it was barred by limitation as the request was made after the husband turned 23 years old. It also noted that the husband had earlier filed for divorce under Hindu Marriage Act, which implicitly confirmed the marriage's validity. Against this decision, the husband approached the Allahabad High Court. The High Court ruled in his favor, declaring the marriage void. The High Court said that the husband could file for annulment until the age of 23, considering the limitation period from when he turned 21. The High Court awarded 25 lakhs as permanent alimony to the wife, but denied her request for residential accommodation. Now, against the order of the High Court, the appellant wife has approached the Supreme Court. She argues that limitation period for filing a petition to annul a child marriage should be based on the male attaining the age of 18 and not 21. According to Section 3, subsection 3 of PCMA and Section 3, subsection 1 of Majority Act, a person attains majority at 18. She claims the High Court wrongly extended the limitation period to allow annulment until the age of 23. Further, she argues that allowing males a longer period up to 23 years to annul a marriage, while females have only up to 20 years, is discriminatory and violates Article 14 of the Constitution. The wife also asserts that PCMA is designed to protect vulnerable parties, primarily females, from child marriage. The High Court's interpretation, she claims, dilutes this protection by extending the time frame for males to seek annulment, potentially leaving the females in uncertain marital statuses for longer period of time. Well, now the Supreme Court has issued notice on her petition and is set to determine whether the age of majority for males when calculating the limitation period for seeking annulment of a marriage under PCMA should be 18 years or 21 years. Stay tuned. The Apex Court has today posted the criminal appeals pending in the 2002 Godhra train burning matter for final hearing as item number 1 on 13th February. A bench of Justices J.K. Maheshwari and Arvind Kumar expressed displeasure about the parties seeking adjournment in this matter and said that no further adjournment would be granted now. During the hearing, the lawyers representing the convicted individuals raised several points. Senior advocate Sanjay Hegde, representing one of the accused, argued that the convicted person person's applications for remission are still pending with the state and should be decided first. He also pointed out that both the convicts and the state of Gujarat have filed appeals with the state challenging the commutation of the death sentence to life imprisonment. He referred to a 2014 Supreme Court ruling which says that cases involving the death penalty confirmed by a high court must be heard by a bench of at least 3 judges. He argued that the appeals seeking the death penalty should first be heard, and if the death penalty is confirmed, the case will be referred to a 3-judge bench. Hegde also noted that the court must consider whether the death penalty should still be applied after 22 years. The judges clarified that each case is unique, so an individualized approach must be taken. Regarding the death penalty, they explained that the conviction must first be confirmed, which a 2-judge bench can do. Once the conviction is confirmed, the next step would be determining the sentence. On the issue of remission, the court rejected the appellant's arguments and stated that remission decisions are to be made by the state and not the court. Justice Maheshwari also mentioned that the Chief Justice's office has instructed that remission and criminal appeals do not need to be heard together, even if the remission issue arises in future. The court today also asked the parties to translate the court records from Gujarati to English and digitize so that they can be accessible to all parties. The matter here relates to the crime which took place on February 27, 2002 and resulted in the killing of 58 persons in a fire inside the S6 coach of Sabarmati Express, which was carrying car sevaks from Ayodhya. The Godhra Carnage triggered communal riots in Gujarat. In 2011, the trial court had convicted 31 persons, of whom 11 were sentenced to death and the remaining 20 were awarded life in prison. 63 other accused were acquitted. In 2017, the Gujarat High Court commuted death sentence of 11 to life term and upheld the life sentence awarded to the other 20. And lastly, while granting bail to Jal Jeevan Mission scam accused Padam Chand Jain in a money laundering case, the Supreme Court today clarified that the order granting bail to former Delhi Deputy Chief Minister Manish Sisodia was not passed in exercise of powers under Article 142 of the Constitution. The bench comprising Justices B.R. Gawai, A.G. Masih and K. Vinod Chandran noted that Jain had already been granted bail in the initial offence. The evidence is mostly documentary and charges have not yet been framed. The bench also considered that co-accused Piyush Jain and Sanjay Badaya had already been granted bail. The court stated that, like in Sisodia's case, the evidence in this matter is documentary and the documents have already been seized by the prosecution, making tampering unlikely. The bench also highlighted that the minister benefiting from the alleged transactions was not named as an accused. The court also clarified that its earlier decision granting bail to Manish Sisodia was not based on the special powers under Article 142 of the Constitution. Instead, the court had ruled that conditions under Section 45 of Prevention of Money Laundering Act, which restricts bail, cannot override the constitutional rights provided under Article 21, such as the right to personal liberty. The court emphasized that keeping someone in jail for too long before their trial starts should not be treated as a form of punishment. The Enforcement Directorate had opposed the bail, arguing that Jain's role was more serious. Despite this, the court granted him bail. For more information on the cases that I discussed here, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share and subscribe to our channel.